afternoon and welcome to the Outer Temple Chambers annual cross-border law conference. For those of you who don't know, I'm Dan Clark, and it's a real pleasure for us to have so many of you watching. I must say I feel a bit like Des Lynam presenting Grandstand. I'm here in the studio in London. We'll be bringing you live action at various points from Chicago, Spain, Manchester, Norfolk, and other places. Some of you will be too young to know who Des Lynam was, but I needn't explain who he was because you'll probably have already Googled him and learned everything you need to know about him before I've even finished this sentence. Let me tell you about the lineup. First, we'll be hearing from Sarah Crowther QC and Will Young on the subject of Brexit. What next? Then at about 10 to 3, we'll be hearing from Ian Denham and Karen Hunt on the subject of the recent calls for appeal case of Griffiths and Toohey. Then at 3:30, we're going to have a coffee break for about 10 minutes. Then at 3:40, we'll be hearing from Chris Deacon from Stewart's Law on the subject of the assessment of personal injury damages under foreign law. Then at about 4:20, we'll be hearing from Gerard McDermott QC and Jack J. Casciato, who's a partner at Clifford Law, one of the top law firms in Chicago. And they will be discussing litigation in the United States, in particular, building a case for trial and the difference between discovery in the US and Europe. So the arrangements for asking questions are going to be as follows. This is an interactive event. We do very much want you to ask questions if you have them. And there are several ways you can do it. You probably know how to do this already, but just to recap, the first way is by using the Q&A box at the bottom of the screen. So if you scroll down to the bottom of your screen, you should see a box marked Q&A. Just simply click the box and enter the question in there. And I will pick it up and ask the panelists at the end of their talks. Do send me your questions while the talk's going on or near the end of the talk, and I'll put them to the contributors when they've finished. I should also tell you this event is being recorded. In fact, when it's done, it's going to be divided up into sections and put on the Outer Temple YouTube channel. I do very much recommend the Outer Temple YouTube channel. There's some excellent content already there. So that brings us to our first talk, which is on the subject of Brexit. What next? Remarkably, for such an important event, Brexit's been relegated at times to the background in this most unusual year. Nevertheless, the UK has now left the EU in March, and the end of the transition period looms very large over us in about 2 months' time. And it's obviously of critical importance for cross-border practitioners, as it threatens to affect jurisdiction, enforcement of judgments, MIB claims, and other issues too. So here today to discuss Brexit, what next, we have Sarah Crowther QC and Will Young. Sarah will be very well known to most of you. She's a leading silk in the area. She's been in several Supreme Court cases in recent years, and you can look forward to seeing her in another one in January in the case of Brownlee. And Will Young will also be well known to lots of you. He's an excellent up-and-coming junior in travel and personal injury. So without further ado, I'd like to hand over to them. Bring yourselves live.
Hi there.
We have Will. Welcome, Will. We have Sarah. Welcome, Sarah. Super.
Thanks, Dan. Hi.
Good afternoon.
Hello, everyone.
Good. Excellent. Well, I can hear you both very clearly. Hope everyone else can. I look forward to hearing what you have to say.
I mean, Brexit is obviously a very large topic, and rather than try and cover absolutely everything, we've picked a few things that seem to be of particular interest, and we're going to focus on those. So unless you had anything you wanted to say at the start, I'm going to put the slides up on screen. There we go. So the starting point for where we are now, obviously, is that we're in the transition period until the 30th of December 2020. And generally, and in practical terms, things remain the same essentially until then. Reciprocity in terms of the various arrangements with the other EU countries remain in place during the transition period, but the key question is what happens from the 1st of January 2021. Taking the various topics, I've started with the easy bit because applicable law is going to be the easy bit of this, because Rome 1 and 2 do not depend on reciprocity, and therefore, and related to that, indeed, they can have the effect to apply the law of a non-signatory state, and so therefore the UK courts can continue to apply Rome 1 and 2 rules despite the UK's departure from the EU, and that's what the government has made clear that they intend to do. And there's a statutory instrument, the snappily named the law applicable to contractual obligations and non-contractual obligations (brackets EU exit regulations 2019), the effect which have been enacted essentially to ensure that Rome 1 and 2 can continue to be applied in the UK courts even after we have finished the transition period, and therefore there's no significant change there. Jurisdiction, however, is going to be rather more complicated, because the Brussels 1A, Brussels recast regulation, will cease to have effect for the UK from the 1st of January 2021. And therefore, on the face of it, in default of any deal or any alternative solution, we will return to the common law rules. As Dan mentioned at the outset, you will be able to see Sarah in action in the Brownlee case in January, which has various aspects of it that go to the common law system. We're not going to cover the common law system of jurisdiction and rules of jurisdiction in detail in this talk, but if there is no deal and if there is no alternative solution, then that's what we will all be dealing with in terms of jurisdiction after the end of the transition period. I've said there, to go back to previous one, I've said there, in default of any deal or any alternative solution. Well, one of the potential alternative solutions that's been mooted is the Lugano Convention, which of course is in very similar terms to the 2001 Brussels regulation prior to the Brussels recast regulation. There are some significant differences, but it would have a broadly similar outcome, or rather it's a broadly similar system to Brussels 1A. And there are a number of sort of more minor differences, but two of the most significant ones I've picked out there. Perhaps the most relevant one for these kinds of personal injury cases that many of us are involved in is the consumer contracts position, because Lugano allows the consumer to bring a claim in the courts where the consumer is domiciled, or the courts of the member state where the other party is domiciled. But that rule only applies where the other party to the contract is actually domiciled in a member state, whereas Brussels 1A, Brussels recast regulation, broadens that out and widens it, and means that it applies even when the other party to the consumer contract is not actually domiciled in a member state at all, so long as the contract meets various requirements, including that the supplier has directed activities towards the member state where the consumer is domiciled. So that is a significant difference between Lugano and Brussels recast in terms of consumer contracts. The other, perhaps slightly more headline difference is the amendment to the Brussels recast regulation to deal with the Italian torpedo, which at the time cue lots of headlines about sinking the torpedo and things like that. The effect of which being that where there's an exclusive jurisdiction agreement, then the court that is designated by that agreement gets to decide on jurisdiction before the court first seized, which deals with the issue of the Italian torpedo, whereby people would bring a claim in notoriously jurisdictions that would notoriously take a longer time to deal with the question of jurisdiction, and therefore sort of subvert the process. And that's probably of less central relevance to the kind of personal injury claims that lots of us are familiar with, because often there will not be a pre-existing contractual relationship between the parties if you're talking about an RTA claim or something like that, and therefore the exclusive jurisdiction clause is less likely to come up. But it is in the wider sense of jurisdiction law, that's a significant difference. The problem, though, in practical terms with the Lugano solution is that we would need agreement for all signatory or current signatory states to the Lugano Convention in order for the UK to be able to accede to it, and that includes all of the EU states, and that has not to date been forthcoming. The EFTA states have given consent, but not Denmark or the EU, and it has been reported that the EU is not the states of the EU are not keen necessarily to give consent to the UK to accede to Lugano in a way that is separated from the remainder of the Brexit negotiations, and it's all slightly wrapped up with that. So I suppose what we're saying is that there's no guarantee that that will be agreed to, and therefore we will be able at all to accede to the Lugano Convention. But in any event, even if that agreement is forthcoming, it would take time. The process itself would take time, so that there would be a period during which the common law rules would continue to apply. And I've just on the next slide set out the timeline, the chronology for how that would work, because the timeline for accession to the Lugano contract comes really in 4 stages. Firstly, the UK would request accession, and that has been done formally on the 8th of April 2020. Then it would require unanimous approval by the current contracting parties, and that's what we don't have at the moment. Then the depositing of the instrument of accession by the UK, and then there's a 3-month objecting period before the convention enters into force, and any contracting party can object during this time, even if they hadn't raised any objections prior to the unanimous approval, because obviously they would have needed to have given their approval for it to be unanimous. So what that means in practical terms is that in order for Lugano to come into force in the UK on the 1st of January 2020, the 3-month objecting period after unanimous approval would need to have started on the 1st of October 2020. And obviously that hasn't happened. So it can't come into force on the 1st of January 2020. And of course, the longer it takes for unanimous approval to be achieved, even if it is achieved, then the later the 3-month period for objections would start, and therefore the later it would be completed. So there's already guaranteed to be at least a 1-month lacuna before the UK could accede. And that's assuming that unanimous agreement was achieved by the end of October 2020. So if it happens at all, the delay may be significantly longer than that, and therefore there would be a significant period during which the common law rules would apply, even if the UK does accede to Lugano in the end. One of the other potential options is the Hague Convention. The UK, after a bit of toing and froing on this, given the moving of the date for the departure from the EU, the UK instrument of accession was deposited for the Hague Convention on the 28th of September 2020, so as to come into force on the 1st of January 2021. And there's a bill in Parliament at the moment that would give the Hague Convention the force of law as from that date. Again, this offers some assistance in terms of jurisdiction, but it relates only to cases where there's been a choice of jurisdiction made in advance, and therefore it may not be relevant to many or most personal injury claims. Moving on to the next topic, really, we're going to just say a little bit about the Motor Insurance Directives. And here there are some significant differences. The Motor Insurance Bureau has worked together with the Council of Bureau in Brussels to try and avoid or minimise disruption to the green card system. And for example, I've said there that there's an agreement reached that the green cards don't have to be printed on actual green paper, which may not sound like very much, but I think the thinking behind it is that it enables people to print off their own ones without having to have green paper to hand. And when Sarah and I were discussing this in advance, I said that must have been a real hammer blow to the share prices of companies that print green paper. But I think in a broader sense, the aim there is to make these things more viable on a practical level and try to keep the disruption to a minimum. But allowing the green card to be printed on non-green paper is not going to solve all the problems, obviously, because the fourth Motor Insurance Directive relies on reciprocity, and that will be lost from 2021. And to take perhaps a couple of the most significant examples of this. If one is thinking about an accident involving an uninsured driver within the EU, a UK citizen suffering an accident abroad in a UK country with an uninsured driver, well, currently, under the pursuant to the fourth Motor Insurance Directive, the claim can be brought by a UK domiciled claimant against the MIB, and then the MIB claims an indemnity back from the equivalent compensatory body in the country where the accident took place. And I've set out there the 2003 regulations that give that effect in UK law. Similarly, the fourth Motor Insurance Directive imposes the obligation on insurance companies to have local claims representatives in all member states to deal with these sorts of visiting victim claims. Now, those are the kind of rights pursuant to the fourth directive that are very useful and valuable to claimants in these circumstances. And those are the kind of things that are going to be lost if there is no deal. And the practical effect of that is that if the right to claim via a local claims representative or to bring the claim against the MIB, if it's an uninsured driver, is lost, then the claimant would have to sue in the country where the accident took place. And the 1999 regulations that I've quoted there are again part of the EU exit day regulatory bonfire that have effect to repeal the implementing regulations as of the 31st of December 2019. So it obviously makes it much more difficult in practical terms if you have to sue the insurer in the foreign country where the accident took place and not in your own language. But it could be worse than that, because if you have to bring the claim against the compensatory body in the EU country where the accident took place, then some countries, for example France, don't allow claims against their equivalent of the MIB by non-residents. So it may be that it's not just a matter of the inconvenience of not being able to bring the claim in your own country, that there may not actually be a claim at all. So that could be a very profound difference between the current regime. The other point there is that if we don't accede to the Lugano Convention, then Odenbright claims, whereby a claimant could bring the claim directly against the motor insurer in the UK courts, would be unavailable, because without something replacing the basis on which that right rests, i.e. Brussels recast, then there is no right to do that, and that right would be lost. In terms of the direct right against insurers within the UK, the European Community's Rights Against Insurers regulations are the regulations that implement that requirement within UK law, and that's the basis of the direct right of action against the against the insurer for UK-based accidents. This is a freestanding UK legislation, and so this right would not automatically be lost on the 1st of January 2021. But what would change is that there would be no binding obligation on the UK government from that date to maintain this right. Now, it has been a little bit difficult to keep track of exactly what the UK government is intending to repeal or amend, and what they're not intending to amend. But it doesn't look at the moment as if there's an indication, as far as I'm aware, that this is going to be amended. There are some currently outstanding amendments to the 2002 regulations, but they seem to be amendments to the interpretation section to make the regulations make sense when the UK leaves the EU. So in terms of the definitions of who is an entitled person to bring a claim under the regulations, so from as far as I can see, it looks as if the intention is for that right to continue under UK law. But of course, I suppose nothing is guaranteed. And the point is that when there's no obligation for the UK government to keep that right in place, then you can't be sure that that's definitely going to remain there. So far, what I've been really talking about mainly has been jurisdiction. The other side of the coin of all of this is the recognition and enforcement of UK judgments in EU countries. And The point here being that even if a claimant can establish that the UK courts have jurisdiction, that is only a practical benefit if the country where the defendant is domiciled will recognise and enforce a UK judgment. And if Brussels 1A or Lugano, or Brussels 1A ceases to apply, and if we don't accede to Lugano, then the national rules of the place where the defendant is domiciled will apply in relation to attempts to enforce the judgment of the English court. I've just put in the slide there the note that in relation to the enforcement, the application of Brussels 1A depends on the date the proceedings were instituted rather than the date on which the judgment is given, which is a potentially relevant factor and is helpful to claimants. But in terms of the practical implications of this, I think our view generally is that if and when and where Brussels doesn't apply and we're not in Lugano, then advice from a local lawyer on the rules in relation to enforcement of foreign judgments will be a sensible precaution, because of course there may well be implications relating to enforceability in terms of the delay that may cause, in terms of the costs. And if the judgment of an English court is not enforceable, or at least reasonably practicably enforceable, and for example if the costs cannot be recovered, then that may well affect the strategy of the claim, and indeed whether it's worthwhile bringing the claim in the English courts at all. So bringing all of that together, the full implications are, we think that there are going to be some significant changes. Inevitably, uncertainty remains, and that every Brexit talk for the last 4 years has been caveated with the fact that there's a lot of uncertainty. But the general point, I think, is that accession to Lugano may solve some of the problems, but that may not happen at all, and it will take some time even if it does. And therefore, in a practical sense, if cases can be issued before the 31st of December 2020, that would seem to be a sensible idea to do so. But we think that whilst a few months ago there may have been an assumption that we were going to accede to Lugano and it would be relatively seamless, we think that it's likely that there will be at least a period where we're applying the common law rules with nothing else.
One of the things that strikes me about the arrangements as they currently stand, in other words, especially reversion to the common law on questions of jurisdiction, is it's going to, if that is the position, it's going to mean a lot more necessity for English lawyers to engage with their European counterparts, even than it does now, which I suppose you might say was a bit ironic, really. I'll give it an example. I mean, if the UK doesn't sign up to the Lugano Convention for whatever reason, or if there's a sort of interregnum period where the common law still applies for any length of time, we'll be thrown back onto the common law rules when it comes to establishing jurisdiction. As anybody who's litigated those kind of jurisdictional disputes will know, essentially what the claimant will have to do, if, for example, they're involved in an accident in another EU country, say an RTA, is they'll have to show firstly they've got a good arguable case, but they'll also have to show that England and Wales is the convenient forum, and that's a discretionary exercise on the English court's part. So there'll be lots of cases where, whereas now an English claimant will be able to sue in England as of right, but in the future it'll be discretionary, and there'll have to be, or there may very well be, lots and lots more jurisdiction disputes based on the fighting, the forum non-convenience point than there are now, when there just simply isn't an argument to be had. And a lot of those disputes turn on sometimes on foreign law evidence. What is the foreign law? Will there be a serious liability issue to be tried or not? Because if there is, then obviously that points to the matter being litigated in the place of the accident. If there isn't, and it's a quantum only exercise, then it points to England. Will there be delay in the proceedings if they're prosecuted in Europe as opposed to here? We might even have the sort of spectre raised of lawyers from EU countries coming to England to give evidence, or giving evidence in a report to say that the justice systems in particular EU countries are very slow and not as quick as England. Just remarkable, really, to think. I think the first point I'd make is if the common law rules do apply, it's going to mean far more jurisdiction challenges than we currently have, because at the moment it's pretty much a rules-based regime under Brussels 1A. There isn't really any discretion, and it's going to mean a lot more engagement for English lawyers with their foreign the EU counterparts, because in litigating those jurisdiction disputes, they're probably going to want input from the foreign lawyer in order to be able to evidence their case on jurisdiction. Another area where I think the English lawyers are going to have to interact with their EU counterparts a lot more than they do now is in the area of enforcement. At the moment, obviously, the judgments regulation means it's pretty much automatic that an English High Court or other court judgment will be enforceable throughout the EU and vice versa, but we're subject to some small exceptions. But if we go to fall out of that system, it may very well be a matter of what treaties currently exist or can be brought into existence to cover mutual enforcement of judgments, and that may very well vary greatly as between the UK and whatever country it is. I mean, it may well be that there's practically mutual recognition enforcements with one EU country, but then perhaps thinking of the more recently acceded states, no one's ever really thought about that before. There hasn't been much call for it before. So there's going to be lots of need to, at an early stage in the litigation, engage with foreign law expertise, EU law expertise in particular, in order to be able to litigate. Whereas now, or under the current regime, there isn't. It just strikes me that that's something that, in terms of practical effects of Brexit, that we as cross-border litigators all need to be thinking about, and something you might say somewhat ironic, really. Will, is there anything you want further you want to say?
Well, I can see in the chat box there's a question about whether, in terms of issuing new claims during the transition period, whether you need to actually serve the claim as well as issue it to remain within the transition period rules. And I think that there's not a clear answer to that, because it's not clear from the withdrawal agreement what instituted proceedings would mean. I mean, my instinct would be that by issuing proceedings, you are instituting them, and therefore that ought to be enough. But having said that, I think it would, if you have the option, I think it would always be sensible to try and serve it as well. And I've got at least a few cases where we're trying to get it served before the end of the transition period, as well as issuing. I suspect in reality it will, but because there will be lots of cases that are not able to be served before the end of the transition period, there will almost inevitably be some sort of litigation and or test case to determine this question. But I think the short answer is probably that the best interpretation, I think, is probably that you only have to issue your proceedings before the end of the transition period. But I think if you can serve them as well, then that would be prudent, I would have thought.
Yeah, I can't really argue with that that analysis. I mean, there was obviously the case of Pandya in recent times, which tackled the question of to what extent are the rules about how you stop limitation running are procedural or substantive, which obviously sent sort of shockwaves through the cross-border world. But I think this is a slightly separate question to that. And I agree with your analysis that on the face of it, it looks like issuing ought to be sufficient. But if you can issue and serve in time, then you should. Definitely. I have another question. So the question is, what do you do you advise to do about service on foreign insurers if we are still able to sue them directly? Do you have any take on that, Will?
I think that if we lose the service regulation, then we'll have to go back to the CPR rules about service. And I think that I just having a look at the question again. I think that with all of these things where there is a degree of uncertainty, there can be a difference between what you think the right answer is and what the absolutely prudent thing to do is, if you're trying to be as astute as you can to protect your client's interest. And I think that that the foreign process section may well be the answer, but I would probably feel more comfortable trying to get some advice from a local lawyer as to what the service requirements are in the particular country. And I think, as Dan said earlier, it is slightly ironic that the loss of these EU rules is meaning that we are going to have to engage a lot more with overseas lawyers to get to the bottom of these types of questions. So I think in those circumstances, I think I probably would want to get some advice from a local lawyer as to what the local requirements are for service.
Yeah, that sounds very sensible. Very good. Does anyone have any more questions they want to send to us? We're running slightly early, which is unusual. There we go. Somebody saying thank you for answering the previous question. Okay. So if the transition period is passed, and if we haven't joined the Lugano Convention, signed up to the Lugano Convention, imagine there is a road traffic accident in Greece, and the claimant's driving a Greek rental bike. The driver and the passenger are both domiciled in England. The passenger can, of course, sue the driver in the English courts. Can he ask the Greek insurer to join the proceedings?
I mean, I think my initial thought would be that if you have established jurisdiction against the primary defendant, being the driver, then it ought to be possible to try to join the insurer, because the English courts will have established jurisdiction in relation to the primary claim, and therefore applying the CPR rules, you could argue that it would be necessary to join the Greek insurer as well, because you'd already have the anchor defendant of the driver establishing the jurisdiction of the English courts, and once that jurisdiction is established, then you in theory, I would have thought, could trying to use that to join the Greek insurer. I think the difficulty, though, would be that whether you actually have a direct right, whether you have a right of action at all against the Greek insurer, because I think without the assistance of Odenbright and Lugano, I think that might be your obstacle as to whether you have a right. Whether you have a right at all. And of course, the other point is that, going back to what we said about enforcement of judgments, is that you'd want to feel confident that you'd be able to enforce any judgment against the foreign insurer, and that you could do so and recover costs in doing so before you took a decision as to whether you were going to add them to the English proceedings anyway. So I think those kinds of practical considerations are likely to be particularly relevant after the transition period.
Yeah, I think that really, I agree with that. I mean, it's really a good example of the difference between the Brussels Convention regime and the common law regime. You can be reasonably confident doing something under Brussels Convention regime as a matter of right, whereas under the common law, you might say, well, be able to advise, well, you've got good prospects of being able to do it because you've got an anchor defendant, and you would hope to persuade the English court that it would be the convenient forum to determine all the disputes and so on. But you can't guarantee it. You don't have the right to do it, and you might very well face a jurisdiction challenge with the extra cost and the uncertainty to your client, involved. So that's the difference. I think it's for those acting for claimants, much more. Less advantageous situation to be in. on the other hand, it probably does mean more work for conflicts lawyers. Is there any other alternative to the Lugano Convention in the event that the UK's request to join fails for whatever reason? Is another question.
I don't think I've come across any particular other alternative being mooted. I think that the hopes seem to be being pinned on Lugano. I mean, there's the Hague, as I mentioned, and we have already acceded to that, but that doesn't cover the same ground as the Lugano Convention, because it only relates to specific agreements to confer exclusive jurisdiction. So I've not heard any particular other suggestions other than Lugano, unless Dan, you can think of anything.
I think the answer I think is there isn't any other ready-made solution that would replicate that. I think there's been discussion about possible other solutions, but that's all really pie in the sky. I mean, that's all. I don't think anything specific has ever been put forward, and something that Sarah's worked quite hard to highlight, and I think in fairness also Bar Council as well, is the seeming lack of priority given to civil justice and cross-border issues by the government in the negotiations. There's been very little attention paid to it really at all for the last 4 years, and it doesn't appear that the UK government really appreciates just how important an issue it is, not just for individual litigants but for the economy of the country. So there's been some discussion about arrangements that might be reached, but it's been very vague, and there isn't really much there. So at the moment, in answer to the question, I don't think there's anything else that's been floated. Another question. This is a lovely question. I'm not going to say who it's from, but he's someone very well known to us. Why are British lawyers so dedicated to starting proceedings in their own country? It could well be that starting proceedings in a European country itself is quicker and better. What an excellent question. And thank you. You know who you are. Yeah. Well, look, yes, I do. We take that point. I mean, I think to be blunt, the costs is probably a big part of it. The cost recovery regime is more favourable generally to English claimants than would be in other EU states. I mean, even compared to the difference between England and Scotland, for example, England is more favourable, so that's one part of it. But I mean, less cynically, has to do with familiarity with the procedure, the language, doing it in your own language, not having to travel. Perhaps there's a perception that the English courts deliver a sort of world-beating, to use that dreadful phrase, service. So I think all of those things go into it, and I suppose English lawyers want to litigate in their own jurisdiction. Most lawyers do. They're familiar with it. They know the ropes. So for all of those reasons, I think that's true. But I certainly take the delegate's point that there is perhaps sometimes a reluctance by English lawyers to look beyond their own borders. But I mean, those would be the reasons, and I think they're all, in fairness, they're all very sound reasons.
And Dan, I wonder just on that point, which goes to that question, but also goes to the sort of forum conveniens questions that are going to be more prevalent once we're operating under the common law rules, which is that one wonders slightly whether the events of the last 6 months will have an effect on both the way judicial proceedings are conducted, but also, therefore, those sorts of convenience type factors that you were talking about. Because if courts around Europe and possibly the world decide, or are forced to decide, as the UK courts have been to a certain extent, that the fact that everyone is working remotely and can't be in person means that there has to be a lot more justice being done via remote methods, then lots of those, obviously not all, but lots of those factors about convenience and travel and having to go to a foreign country to litigate your claim may be lessened if everything is being done by Zoom. So it may be that in future UK lawyers are a bit reluctant to step outside their shores, and indeed it would be less. It might be that it's less of an inconvenience for UK claimants to do the same.
Yes, one delegate has made the very good point that the quantum rules tend to be more generous in this country than they are in other in EU countries, and that's a very good point, because often the case, especially when it comes to future loss of earnings and care and things like that, which are often the really big heads of claim. Not universally, but I'd say most of the time. Well, thank you very much.
Thank you. Thanks, everyone.
Yeah, Will, I'd like to just thank you very much. That was excellent.